in person. We have Bruce Anderson, defense counsel, in person. Mr. Benjamin is also in person. We're set today in this matter for a plea and sentencing. One of the requirements was to prepay restitution in the amount of $2,691.68. Mr. Anderson, off the record.
Part 1. Focus. Court opens. Defense and DA present. Restitution of $2,691.68 confirmed. Defendant ready to pay cash. Judge notes how upfront payment shows accountability and can affect outcome. Tension builds. Will paying cash influence probation? Set stage for plea.
The court that your client is ready to pay that here today. Is that correct?
It is correct.
And for confirmation that they have, or your client has, that total amount that I've just stated on the record?
Yes.
Okay.
And I trust we'll pay that to the DA's office.
I believe it gets paid to the clerk.
The clerk.
Yeah, you pay it to the clerk, and then the clerk issues, I believe, a check to the district attorney's office, or the clerk actually issues the restitution check to the victim.
And I may have misheard, but the total was $2,691.68.
Yes. Okay. That's what I have.
Okay.
Is that
it is correct according to the worksheet that I have, yes.
Okay. All right. So do you have a plea question or waiver of rights form, please?
I do.
Thank you.
I'm going to make one comment up front. Mr. Schmidt and I never, I don't know that it would have been necessary, discussed the possibility of expungement. And I think that's something that I would ask the court to leave, that the court consider at this time also.
And also, I'm seeing.
Focus. Defense explains choice of no contest plea to avoid civil consequences. Tavern fight background. Defense of brother. Legal nuances discussed. Judge evaluates the plea's validity. Suspense. Will this strategy protect defendant while keeping him legally accountable?
That you are requesting a no contest plea.
Well, I think there's civil ramifications.
And that's where I was going. I would like you to make just a statement on the record as to why you would be requesting a no contest plea in this matter.
I will. Right now?
Yes. Right.
All right. In reviewing the facts and the whole matter, it was an incident outside of a tavern. Everyone had been drinking. There had been arguments going on that were ongoing. My client's brother had been attacked by the victim's group. The defense of others, which is permissible under Wisconsin law, I think would come in both in a civil as well as would have been a defense in a criminal case. But in a civil matter, I think it's something that my client would have to assert in the event that he is.
And he would like that extra legal protection.
Yes.
All right. So I understand that. So a no contest plea is granted or available in this matter. All right. Can you please state the agreement on the record, Mr. Anderson?
My client will enter a plea of no contest to an amended charge of misdemeanor battery. Counts 2 and 3 will be read in and dismissed. The joint recommendation to the court is that he be placed on 1 year of probation. And as I indicated to the court, my client has brought with him cash of $2,700 today to make the restitution immediately after the plea.
All right, thank you. And again, for the record, in understanding this a little further, I have a basis from your statement, Mr. Anderson, as to the public interest, and from the defense side with the public interest. I'm going to guess also with the agreement that's been reached that Mr. Benjamin doesn't have a criminal history or a lengthy criminal history.
You have nothing, do you?
Nothing.
And so that is that the reason the offer has been amended in this way?
I do believe that he has a misdemeanor DWI in Hennepin County, and that.
Focus. Charge amended to misdemeanor battery. Counts 2 and 3 read in and dismissed. Restitution, probation, and potential expungement outlined. Defendant question on understanding constitutional rights, penalties, and implications. Will he grasp the full consequences of the plea?
Is the only criminal conviction that I could see. So that is one of the bases. Also, our office has had communication with the victim, and it seemed that the victim goal was simply just to be made whole for those medical bills that weren't covered, as well as a couple of other things that were indicated on the restitution worksheet. So I do believe that this is in the public interest. Mr. Benjamin is also very young. So I think that avoiding a felony is appropriate and in the public interest for that reason as well.
And does state oppose the request for an expungement upon successful completion of probation in all conditions?
No.
Okay. Yeah, so I have now a broad understanding. Mr. Bronson is a young man. This was essentially a bar fight, or a fight that occurred amongst a bunch of individuals after partaking in beverages that could have an intoxicating effect. So I understand the reasoning behind the agreement. So formal motion to amend count 1 to misdemeanor battery.
So made.
Granted. I have in front of me, Mr. Benjamin, a plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
And did your attorney go over this document with you thoroughly?
Yes.
Did he go over it essentially with you word for word?
Yes.
And do you understand it completely?
Yes.
And if you did not understand something, did you have him explain it to you thoroughly?
Yes.
And he did so.
Yes.
You were pleading guilt or no contest to 1 count of a misdemeanor battery. Is that correct?
Yes.
You're 20 years old. You have 12 years of schooling, and you can read, write, and you understand the English language.
Yes.
Did your attorney go over with you what the state would have to prove your guilt to this charge?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
You are not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours.
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Next to the rights are boxes. Each of those boxes is checked. That tells me that you understand all of those rights. Is that correct?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
You understand them thoroughly?
Yes.
Do you understand that by pleading guilt or no contest, that you are waiving and giving up those rights?
Yes.
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
Yes.
Do you understand that the state would have to prove as to a misdemeanor battery that you caused bodily harm to a victim, you intended to cause that bodily harm, the victim did not consent to that bodily harm, and you knew the victim did not consent to the bodily harm? Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or up to 9 months of incarceration, or both?
Yes.
Do you understand also that there is a recommendation for the court to place you on 1 year of probation? Do you understand what probation is?
Yes.
And do you understand that I don't have to follow that recommendation for probation? I could sentence you today all the way up to the maximum possible penalty, which could be jail.
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes.
Or excuse me, not guilty, no contest.
Yes.
All right. Now, did you go over that criminal complaint with your attorney? And in particular, there is a section, and it's called the probable cause section, where it basically says what happened that day and why you were charged with the crimes?
Yes.
For the most part, well, I'm going to have you make a statement, Mr. Anderson, as it relates to a factual basis, so as not to open up any potential civil liability or ramifications.
Thank you. We are stipulating to the fact that within the probable cause section of the criminal complaint, we believe that the prosecution could prove all elements of the amended charge. The evidence, we believe, would show that, in fact, my client during the ongoing incident did strike the victim and that the victim received a laceration and did in fact go to a hospital for medical treatment that did include care. And that, I think, is sufficient.
All right, thank you. Has anyone made any threats or any promises to you, Mr. Benjamin, for you to plead no contest to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what.
And there it is.
Are you satisfied with your attorney service?
Focus. Prosecutor and defense argue for probation. Victim wants medical bills paid. Defendant highlighted as young, employed, responsible. Judge considers age, prior record, and restitution. Suspense. Will the judge prioritize punishment or recognize defendant's accountability and youth?
Yes.
Have you discussed this matter in full with your attorney?
Yes.
And you've discussed what options you have, like if you were to go to trial, if you would have any defenses or a lack of defenses?
Yes.
So you're satisfied with his services?
Yes.
Okay. Do you have any questions for the court or for your attorney before I proceed?
No.
As to the amended count, misdemeanor battery, how do you wish to plead?
No contest.
No contest.
Court will find your plea of no contest has been done freely, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea. Based on that, I find you guilty of that count. Count 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Ms. Rocco.
Your Honor, I'd ask the court to adopt the joint recommendation. As I've already said, I think that this is in the public interest. The victim is going to be made whole with that restitution amount paid in full. And I think that that's sufficient. Certainly, I think Mr. Benjamin learned a very serious lesson here. And he's taking responsibility for what occurred. I think that a year of probation is sufficient to ensure that the victims kept safe, the public's kept safe, and that there is some consequence beyond just paying that monetary amount to the victim. But again, the state doesn't object to the extensibility.
Thank you. Mr. Anderson?
Yes, Your Honor. I think one of the most important things about my client, he's finished high school. He was only 19 years old when this event occurred. He's now turned 20. He's been fully employed, at least since I've been representing him. In fact, the money that is being paid today is money that he had been giving his mother out of each and every paycheck, knowing that he had expenses coming up. And one of the court staff is going to get the pleasure of counting out a whole stack of $20 bills. But nonetheless, that's how they've been doing it. His mom's been holding the money. So it's not like he's got a parent or a sugar uncle or something paying the bill. This is out of his pocket. And I think that shows a level of maturity in facing this matter appropriately. With his taking responsibility like this, his education and his full employment, I don't think there's much more that I can say about him. I guess he had a DWI that I wasn't aware of in Minnesota, which is a misdemeanor crime in that state, not here. But beyond that, he has not had any issues with the law, and I would certainly encourage the court to adopt this agreement, along with the fact that we're asking for restitution. I'm sorry, asking for expungement, and this prosecution does not oppose that. Thank you.
All right, thank you. Mr. Benjamin, do you care to make any statement here today? Let me know anything.
No comments.
No comment? Okay. This is a fight. This is an incident that went wrong. It's involved alcohol, perhaps a lot of alcohol. And in the facts, as I'm reading them, I'm going to tell you, I just had a conversation with my children when they were joking about breaking a glass bottle over somebody's head. And I said, well, usually you can't do that. It's not really possible. You would probably hurt somebody, give them a concussion, because my children didn't realize that in the movies they're made of sugar. They're sugar glass. It's not real glass bottles. But here, a glass bottle was broken over somebody's head, and it caused injury, where the individual needed to go to the hospital and have the injuries treated. I am really glad to hear, though, even in the facts of the case as they are alleged in the criminal complaint, everybody appeared to, even though there was hostility and fighting, in the end, it appeared that they were apologizing and people were, saying, I'm sorry. And I'm glad to hear that everybody appears to be over the incident, even coming from the state, that the victim's main priority and focus was just getting the money paid back for the out-of-pocket expenses from the medical. And you're being made whole by you're making him whole, and you're taking responsibility, and you are being accountable. You are paying all of the money out of your paycheck, and you're doing it yourself as a 19-year-old, now 20-year-old young man. That's accountability. And now you have a criminal charge that's hanging over your head for a period of time. If I may, Mr. Anderson, can you confirm the exact amount with his mother, how much she has with her right now?
Ms. Rocky, how much money do you have of Bronson's to pay?
$2,700. All right, so that's enough to cover the total restitution, and I have $500 in cash, and that's enough to cover the court costs and fees. I'm debating here. I mean, this is an incident where it sounds like you were coming and being a protector and trying to protect your brother. You shouldn't have been in that situation to begin with. You're 19 years old. You shouldn't have been around alcohol. I don't know if you were partaking. I don't want to know if you were partaking. I'm debating whether or not to even put you on probation if you have needs or services or something of that nature. But since you are 20 and this did involve alcohol, perhaps at least at minimum an AODA assessment. So what I'm going to do is I will follow the recommendation for the 1 year of probation. I'm going to give you the ability that if you meet all of the conditions of probation, and that means to the letter, to the T, and you're already going to meet most of them by paying off the restitution and paying off the court costs and fees. Those are the two big ones. And then I'm going to give you a couple others. And if you meet those and you do them timely and you get them done, I approve and I'm okay if you discharge off of probation after 6 months. All right. But the final say comes from Department of Corrections. I sign off of it. In the end, they have to get my final approval, but they make that decision of whether or not they think that you're ready to discharge. But I see right now in front of me that, again, it's that debate of whether or not I should even put you on probation. But at the very minimum, if you would have come here today and said, you know what, Judge, I went through an AODA assessment and I did a little bit of some therapy and try to figure out, if I needed anything else, most likely I wouldn't have even went and put you on probation. Well, those are the reasons why I am putting you on probation. So I will do the 1 year of probation with the ability to request from Department of Corrections to be discharged after 6 months. Conditions are to pay the $2,691.68 in restitution. You're going to do that today. I'm assessing $500 in court costs and fees. You're doing that today. I have that in bond. You're all good. Those two are done. The AODA assessment and any follow through. So that means contact Aurora, get that set up, and do the follow through. So if they say, well, you need to do 2 sessions of therapy or 4 sessions of therapy, that means you just have to do those and then you're done.
Focus. Judge decides on 1 year probation with potential early discharge after 6 months. Conditions include restitution, court costs, and AODA assessment. The golden ticket moment. Defendant avoids jail, but must meet conditions. Audience tension. Can he follow through and benefit fully?
Gainful employment. You're employed. And it's just don't commit any other crimes or anything that would rise to a probable cause of committing a crime. There's not much here that I see you need. You're doing the things. So if you do all of those things, then I have no problem with you being able to discharge after 6 months, okay? And I'm doing the withheld sentence. I'm not going to say you have 6 months or 9 months of jail hanging over your head because, again, I probably would have just held you with the fine today and held you with the restitution, but for the fact that I didn't have that AODA assessment prior to. I am going to grant you the ability to have this expunged as well. So at that 6 month mark, you can have it expunged as well, because I think you're going to benefit. You're going to have this expunged off of your record. It's not going to hold you back. You're going to be able to excel. And I'm hoping by excelling, that means you're going to look at some other type of higher education. It doesn't have to be college. It can be a trade school, welding, go into lineman school, or, mechanics. We need more mechanics. That's dying. People aren't doing that. Plumbing, electrician, something like that. I don't know what you're doing now for work, but what are you doing?
I cut wood for the tribe.
That's awesome. We do need tree cutters too. And my gosh, it costs a lot of money to cut down a tree. Ask me, I cut down 4. It's a lot of money. That's a good profession to get into as well.
Focus. Judge grants possibility of expungement, offers life advice, and emphasizes education, work, and responsibility. Defendant receives practical instructions for DNA and probation setup. Final suspense, redemption, and a clean slate hinge on compliance. Ends with positive, forward-looking tone.
So keep with that and don't just cut wood and cut firewood. Get into the whole cutting of the limbs and cutting down the big trees. Do those things and better yourself and better your life. I want to see you do that. And so I think having it expunged will benefit you. And it's definitely not going to harm the community because you're going to be doing better. And so the community will be doing better when you're doing better. So I would grant the ability to have it expunged as well. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. So when you're done here, you're going to go to the sheriff's department. You're going to provide that DNA. And once you do that, you'll be free to go. But then go right to probation and get probation set up. All right. And then I'm going to tell you right now, and I know Mama's listening, I'd go right to Aurora and get that AODA assessment done. You have to pay $285, $287 at some interesting number like that before they'll even schedule your assessment, because you have to pay that before they'll even give you your appointment. But get that done as soon as you practically possible, because once you get that done, that's your other check off that list. And then you're one step closer to your 6 months, and you're one step closer to getting it expunged. All of those things, okay? I think that covers everything. You've paid everything. You've done everything. What am I missing, Ms. Rocco?
Nothing, Your Honor.
Mr. Anderson?
Nothing, Judge.
All right. Thank you.
Yep.
We are excused.
I'll get you your form.
We are adjourned. Actually, we are